This is Lakshmi from Chalapati Institute of Engineering and Technology, and my topic from cyber laws and ethics, and the topic is intellectual property. So let me know first of all what is intellectual property. So intellectual property is a person's personal property. So these are two types, tangible and intangible. So tangible properties like physical properties, and those are physical properties like lands, vehicles. These are the physical or tangible properties, and intangible properties are a mental process or a mental resulting process. These are the intangible like logical properties, and those properties have owner's rights to protect the profit from the use of his property is called as intellectual properties. So the right to protect the owner's profit is called as the intellectual property rights. So an intangible personal property resulting from a mental process to protect of the owner's right to protect profit is called as a intellectual property rights. And the types of intellectual properties are patents, copyrights, trademarks, trade names, and trade dresses. So in these, the first one is patent. So these are the intellectual properties. So to protect these types of intellectual properties, the rights, we have three types of rights: intellectual property rights, federal rights, and international protection rights, and the common law rights. So these are the rights to protect the intellectual properties. So the first one is patent. So patent is a legal monopoly granted by government, and it allows the inventors to exclusive right to make, use, and sell the inventions from the for the 20 years. So the patent applicant must demonstrate to the patent office that can inventions discovery or design a patent in a non-obvious or novel and useful. So it cannot be in obvious considering current technology. So the patent is a right to monopoly of an invention. So it would be inventor specify the scope of activities from which and he wants to execute. So he wants to exclude the others or a claims and submit the patent office. So the patent office evaluates the these claims district and invent and inventions within the sense of a patent law. So and the invention is correctly disclosed to the industrially applicable, and some patent office will moreover examine the whether the invention is new or old, and a non-obvious means substantial examination. So if the application is a passes examination handles the patent office grants the applicant exclusive rights to produce the market to invention of the period of 20 years. So this is the patent. So if you want to take a patent, these are the requirements for the patent. So in this we have in patents we have three types of patents. So the first one is a utility patents, and next one is a plant patent, and third one is a design patent. So the first patent is a utility or a function patent. So it protects the way to article is used or works must be reduced in a tangible form. So the patents like and the second one is a plant patent. So the plant patent is a new asexually reproduction of a distinct variety of plant other than the tuber propagated plant is called as a plant patent. And the third one is a design patent. So design patent protects the way an article lesser term protection of 14 to 15 years of. So for it consists of visual ornamental characteristics embodies and to apply article of manufacturer. So the patent holder give notice that article or design is patented by placing on the word patent or pat plus the patent number. So the a firm make uses or sells another patented design, product, or process without the patent owner's permissions to thought of patent infringement exist. So, what are the requirements for a patent? So, the first requirement is to obtain the patent to new invention must be in a novel format. So, in a novel, not in a novel means not known or used in this country, not published anywhere is called as a novel. And the second one is no, 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 non-obvious. So it cannot be obvious way to do something. So useful must be have some application even if not commercially practical. So patent applications and issuance. So property between two inventors, generally the person first to invent first to invent and use the product is given the patent even over an earlier field. So prior sale must be apply the patent within a 1 year of a selling product. Provisional patent application, shorter cheaper way, file or patent temporarily to determine if the invention is commercially practical. So patent office grant the patent is subject to the judicial review in a patent infringement cases. So this is the link to apply patent. So major patent issues are human genome and gen patents, pharmaceutical and agrochemical products. So on these products we can take a patent. So next one is copyrights. So copyrights an intangible right to given the author or a certain literally artistic productions. So it works on the created after January 1, 1978 are automatically given statutory copyright protection for the life of a author plus 70 years. So the house of expired 95 years of after the publications or 120 years from the date of creation, which is ever the first. So the multiple author expiration is 70 years after the death of last surviving author. In fact, facts are not copyrightable, and the employer is owner of works is the higher work created within the scope of employment unless the otherwise agreed. So exist of automatically upon the creation of an original work, but placement of a copyright symbol gives notice and not judicially enforce the copyright requires the registration with us copyright office. So what is the fair use of copyright is the reproduction of copyright works for the criticism, comment, and news reporting, teaching, scholarship, or research. So this is the fair use of the copyright. So infringement. So to improve the violation of plaintiff must show the work original. These are the uses of copyrights. So first one is the purpose and the characters of use, including whether such use commercial nature and the nature of the copyrights works, the amount and sustainability of the portion is used, the relation of the copyrighted works as whole, and is based upon the potential market. So these are the based on the computers softwares, copyrightable aspects is codes. In codes, both source and object codes are also copyrightable, and the structures of the system, how the program accomplishes a task and looks internet. These are the examples of copyrights: writing novels, textbooks, and computer softwares, songwriting, song recording, and PPT slides, and journals, textbook, authors. These are the copyrights examples. And trade names, so trade names identifies a company or partnership or business, so it cannot be registered under the federal laws unless they are used. Also trademarks are trade names, and trade dresses also service, like service marks, so used to identify services. So these are the common law, these are all comes under the common law protections. So thank you.